Prince Harry's plan? To keep his late mom, Princess Diana's memory alive by bringing his kids to her gravesite.
Charles Spencer buried his sister on an island so nobody could reach her. Water on all sides. No path, no lens. 29 years on, one of Diana's sons walked that ground with a camera and put it online. The other crosses the water and tells no one. And in March 2026, a charity founded in her memory filed a claim in the High Court of England and Wales against her younger son, naming him a defendant under his own mother's name. Same childhood, same grief, same inheritance. So how did one legacy send two brothers in opposite directions? The island she was meant to be safe.
And every day people tell me what an inspiration she was, how much they miss her, what they did the day she died. It's extraordinary.
On Charles Spencer has written that the location of his sister's grave was deliberate. The lake is a buffer. No path in, no casual visitor, no lens. Whatever else the Spencer family could not control about Diana's life, they could control the last 40 meters of ground around her. In July 2026, during a UK visit, Meghan posted an image on Instagram showing Harry and Archie carrying bouquets, with Lilibet walking beside them down a grassy path lined with trees and hedges. Faces turned away from the camera. People magazine, briefed directly by the Sussex team.
Sentebale started as a very urgent response to the urgent need for those who were impacted by HIV and AIDS in Lesotho to be taken care of.
Reported that the estate was Althorpe. The bouquets, the path, and the direction of travel made the destination obvious. The defense offered by supporters is reasonable enough on its face. The children are not identifiable. The grave itself is not shown, and a man taking his children to his mother's resting place for the first time is doing something most people would recognize as ordinary and human. But the objection was never about who could be seen in the frame. It was about the fact of a frame existing at all. The backlash was immediate, and it did not come only from the usual critics. Commentators who had defended the couple through worse weeks found this one harder to explain, largely because of the couple's own record on privacy. 6 years of statements about intrusion, about children being shielded from lenses, about the right to a life outside the picture, and then the most protected location in the family history arriving on a public feed. Commentators reached for the same word Spencer had used decades earlier. Reports said William was privately appalled and that the king was taken aback. There was a second detail, and it sharpened everything. Prince George had turned 13 days earlier, and the Prince and Princess of Wales had released a portrait to market. The Sussex images followed the next day, including Archie photographed in an aircraft cockpit, echoing a shot of George in a plane. Some commentators call that coincidence and point out the Sussexes were in the country for a fixed window. Others place it in a longer sequence and argue the timing is the message. What is not in dispute is the effect. The Wales birthday portrait lasted one news cycle. Stay with this, because the photograph is not the reason this year splits the brothers. A document filed in March 2026 is. Subscribe now so you do not miss what is in it. The charity that carries her name.
What Prince Harry wanted to do was to eject me from the organization, and this went on for months. It went on for months through bullying, harassment.
Sentebale means forget me not. Harry chose it. He co-founded the charity in 2006 with Prince Seeiso of Lesotho for children living with HIV in Lesotho and Botswana, and for close to 2 decades, it was the piece of his public life that critics and supporters agreed on. No Netflix camera was needed to validate it. It was Diana's instinct, transplanted onto a continent she had worked in herself. In 2025, that ended. Following a bitter leadership dispute, Harry and Prince Seeiso resigned as patrons, saying they did so with heavy hearts and describing themselves as devastated. The board chair, Dr. Sophie Chandauka, remained in post. Then, in March 2026, the charity commenced proceedings in the High Court of England and Wales. Sentebale announced on its own website that it was seeking the court's intervention, protection, and restitution. 2 defendants were named, the Duke of Sussex and Mark Dyer, a former trustee, former army officer, and once an equerry to King Charles. The board's stated basis was a coordinated adverse media campaign conducted since 25 March 2025, which it says caused operational disruption, reputational harm, and cyberbullying directed at the charity and its leadership. Harry has denied wrongdoing throughout the dispute, and none of the claims has been tested at trial. Consider what that means in plain terms. A children's HIV charity, built in a dead princess's name by her son, has gone to court against the man whose idea it was. The detail of the pleaded case is not yet public, and until pleadings are served, nobody outside the parties knows precisely what words are complained of. What is already public is who filed it. The woman who said no. Sophie Chandauka is a lawyer by training, with a career that ran through JP Morgan and Meta before the charity. She grew up with little, was educated in Canada and then in Britain, and holds an MBE. Royal commentators reviewing the dispute keep arriving at the same observation. This is not an opponent who folds. She had already reported the charity to the Charity Commission before the lawsuit existed, alleging bullying, harassment, and misogynoir. In her Sky News interview, she described a culture in which board members were reluctant to challenge the Duke and used the word belligerence about his conduct in meetings. A board of experienced professionals, she says, sat around a table and hesitated to argue with a prince. Her account of a Miami polo fundraiser is where the dispute became vivid. She says a Netflix crew was brought in without advance notice, that the venue withdrew because the event had become commercial, and that costs escalated as the team scrambled for a replacement. She says the Duchess attended unannounced with Serena Williams. Then came the trophy presentation footage that traveled the world, appearing to show Meghan directing Chandauka to move aside. Afterwards, she says, Harry's team asked her to issue a public statement defending Meghan. Her stated answer was that the charity would not become an extension of the Sussex PR machine, and that the greatest risk to the organization was the toxicity of its lead patron's brand, not funding, not politics, the founder. The Sussex side has disputed her characterization of events, and her allegations remain untested in court. But one senior barrister reviewing the case on camera offered a short verdict. He may have met his match. The reason has less to do with the allegations than with the rules Harry is now playing under. What the other brother did with it. Across the same period, William did almost nothing publicly with his mother's name. He has kept his involvement with the Diana Award to a handful of appearances, made no documentary about her, given no interview relitigating her death. He visits Althorp with his wife and children, and nobody hears about it afterwards. That absence of activity is the whole comparison, and it becomes visible only when you set it beside a court file. The rule that runs against him. In every legal fight Harry has picked, he was the claimant. Mirror Group, News Group, the Mail publisher, the Home Office. He chose the timing, the ground, and the exit. Here, he is the defendant. As barristers have pointed out, a defendant cannot walk away, and it is Chandauka who now sets the pace and decides whether the matter settles or runs to public judgment. English defamation law compounds it. In the United States, the person suing carries the burden of proving the statement false. In England, the burden sits with the defendant. Whatever Harry is alleged to have said about Chandauka is treated as untrue from day one, and it is for him to prove, on the balance of probabilities, that it was true. It is worth being fair about what that does and does not mean. A reversed burden is not a finding against him, and English courts dispose of weak claims at preliminary stages all the time. Harry may well clear it. But there is a second stage that has nothing to do with who is right, and lawyers describe it in language they do not usually reach for. The nuclear stage. The word one senior criminal defense barrister used for English civil disclosure was nuclear. Both sides must hand over every relevant document, emails, material held on personal devices, messages sent to anyone about the subject matter of the case, and, as he specified, communications with journalists. The single protected category is legal professional privilege, correspondence between a client and their lawyers. That protection is absolute. Everything else relevant is disclosable, and where a party is suspected of withholding, the other side applies to the court for an order specifying what must be produced. It is slow, thorough, and in his description, a tremendous weapon because of what it surfaces. Consider what that means here. Messages exchanged with Mark Dyer about the charity and messages exchanged with Megan about Sentebale are potentially in scope, not only since proceedings began, but going back to the origins of the tension. The same barrister raised, unprompted, the scenario of a defendant simply deleting material and confirmed on camera that doing so would be unlawful. He was describing a general risk, not making an accusation against anybody. What registered was the context. Harry built his reputation as a litigant on this exact mechanism, demanding internal emails from newspaper groups and winning headlines with what came out of them. The instrument now points the other way, and there is a question underneath all of it that nobody has answered. Sentebale has confirmed publicly that the legal costs are not being met by the charity, and that no donations are funding the case. She has not said who is. Somebody has committed to bankrolling a multi-year high court action against the Duke of Sussex and has chosen to remain anonymous. One barrister floated a theory on camera and was careful to call it a guess. A newspaper group with years of Harry's litigation behind it, seeing an opportunity to answer through a third party. There is no evidence for that, and it may be entirely wrong. But even as a guess, it captures the shape of the thing. A trial is not expected before late 2027, which leaves roughly 18 months of pleadings, preliminary hearings, and disclosure, landing in the same window as the Invictus Games in Birmingham. And it is in that same window that the brothers are due to be put in a room together. The last door between them. The Diana Award is the final patronage William and Harry still share. According to the Mail on Sunday, the charity is planning a program of events for 2027 to mark 30 years since Diana's death, with a black tie gala as the centerpiece, and both brothers expected to be invited. The detail that has drawn most attention is scheduling. The Mail on Sunday reports the gala is likely to be timed around the Sussex's trip to Birmingham for Invictus, not around the diary of the future king, around Harry's. The charity's own logic is defensible. It exists to honor Diana. It has alternated carefully between the brothers for years, and a 30th anniversary without both of them is a diminished occasion. Wanting publicity is not a scandal for an organization that runs on it, but a source quoted in the same reporting says Meghan wants to attend, and that Harry wants her included. William's position, as commentators describe it, has not moved. Nothing official connected to his mother involves her. If both attended, it would be their first joint public appearance since the funeral of Queen Elizabeth II in 2022. In 2017, for the 20th anniversary, they stood together at St. James's Palace without difficulty. By March 2024, the charity was already working around the problem, with William attending in person and Harry appearing by video link. The concern attributed to William's side is not the evening itself, it is the photograph and what one image of two brothers under Diana's name would be worth by the following morning to everyone who has profited from the estrangement. It was never about you. Diana had the most photographed face on earth and spent her working life pointing it at other people. The handshake on the AIDS ward was not about her. The walk through the minefield was not about her. She made herself the smallest thing in the room so the cause could be the biggest. Her younger son took that instinct and put her name on a charity for children with HIV. That charity is now suing him in the High Court. The law presumes his words about its chair untrue until he proves otherwise, and messages he sent about her may end up in a public court bundle. He said his family was trapped and that he had escaped. Her elder son carries the same mother, the same surname, and the same grief, and has never had to explain any of it to a judge. He crosses the water at Althorpe with no announcement, and the island stays what Charles Spencer built it to be. One son treated the legacy as a platform, the other treated it as a rule. If you want more breakdowns like this, subscribe. Then tell me in the comments, was Diana's legacy something to be carried quietly or something her sons were always going to fight over?